Good.
This is not our last meeting.
Good morning, everyone. This is the House Judiciary Non Civil Committee. We're here to consider four measures. Let me say off the bat, HR 1417, the Joint Study Committee on Cultivation Manufacture. That resolution is going to be held for a day. It needs some continued work on some issues, but I anticipate members of the committee that we're going to go ahead and have a meeting likely at the lunch break. Of course, I don't know exactly what time that'll be, but I'll reserve a room for the lunch break where we can go ahead and do a quick convening and a quick review of that resolution. It is a study committee, so it doesn't necessarily have to be out tomorrow. We'd like to get it out by the end of tomorrow, and I think the lunch break tomorrow would be the ideal time to do that. But it requires a little more work on it to refine the language. And we'll go ahead and get you a notice on that ASAP for tomorrow at the lunch break. 1417, correct. Let's start out with SB 154. Senator Kirk isn't here, is he? I don't expect him to be. But Senate Bill 154, what we have done is substitute, if you take a close look at that, we've taken Mr. Setzler's 1006 language, which we amended onto SB 335, and we have this is sort of an insurance policy. We've gone ahead and put that language onto SB 154. Senator Kirk has graciously, for the second time now, allowed this bill 154 to be used as a vehicle for other subject matter. In the event that 335 again gets bogged down in the process, we wanted to have a vehicle ready to go for the Senate to consider in the final days of the session on that important issue. And it's again the exact same language that this committee has previously voted on House Bill 1006. So with that, let me ask for a motion on. Can I get a motion on SB 154? Mr. Reeves moves do pass. Mr. Coomer seconds. Are there any amendments? Seeing none. I see a light flashing, but that's not for an amendment, is it? No. Okay. Any amendments? Seeing none. Any further discussion? All in favor say aye. Aye. Opposed? The ayes have it, and the motion's adopted. So SB 154. I thank you again to Senator Kirk for his kindness in allowing us to use that vehicle for important subject matter that's right now on 1006. Okay. So let's move to Senate Bill 315. We're going to move. We had an extensive hearing on Tuesday on this. I know there have been some conversations back and forth on the issue. Let me do this. Let me call on Mr. Coomer to set the table on this. I know there were some conversations between Mr. Coomer and Mr. Setzler on our approach. Mr. Setzler was subcommittee chair on 315. Mr. Coomer is the House sponsor. So let me ask Mr. Coomer to set the table on that, and then we'll proceed directly to a motion.
Thank you, Mr. Chairman. We're going to be traveling on a motion for passage of LC 298074S, which is the version the committee had before it on Tuesday. I believe Chairman Setzler intends to offer an amendment, or I can offer the amendment to change the word on line 18 to change the word "and" to "or," so that subsection 2C would read cybersecurity active defense measures that are designed to prevent or detect unauthorized computer access, or. I'm amenable to that. The amendment is good with me, and I would ask the members to support that amendment and then support passage of the underlying bill. And Mr. Chairman, at the appropriate time, I'm happy to make an argument for the bill in general, but I don't know if you want me to do that now or later.
No, I think we exhausted that on Tuesday, honestly. It was a good discussion, good perspective on either side, but I think what it comes down to is that I think we do have to act given the time, where we are, in the current reality in the context of when the original statutes were passed on this subject matter, which I believe were in the early 1990s. Mr. Sessler, did you want to add anything to that, or just go ahead and go to the motion, and we'll go from there? Mr. Sessler. Mr. Sessler moves due pass of Senate Bill 315 LC 298074S. Is there a second?
Second.
Second by the Vice Chair. Are there any amendments, Mr. Coomer?
Yes, Mr. Chairman, I would amend by striking the word "and" on line 18 and replacing it with the word "or."
Mr. Coomer moves to amend SB 315 LC 298074S on line 18 by striking the word "and" inserting the word "or." On line 18, striking the word "and" inserting the word "or." Is there any objection to the amendment? Is there any objection to the amendment? Seeing none, the amendment is adopted. Are there any further amendments? Mr. Bodie.
Yes. Mr. Chair, we have an amendment. I want to amend when we have subsection B, access to.
Let me ask you to speak into the mic, because I'm
sorry, it's not on. I don't think it's on.
Yeah, it's on now.
It's on now?
Yeah.
So, Mr. Chair, I would like to amend subsection B, which is line 17. You all have the amendment, the proposed amendment in your package.
This is AM 292793. Is that correct?
Yes, sir.
AM 292793. Is there any member who does not have the amendment? Mr. Bodie.
Yes, so what we want to do is pretty much, I'm not going to move forward on the unlawful act that we talked about on Monday as the proposed First Amendment, but we will be moving forward on the 2 and 3 proposed amendments. One deals with legitimate business activity, which is division number 1. Division number 2, we're talking about by any individual who's acting within the scope of his or her employment. We talked about that on Monday as being the innocent employee clause. And more importantly, division 3, by any person that upon discovering their vulnerability reports such vulnerability in writing to the vulnerable person. I know on Monday we had a lot of discussion on whether a hacker, and Chairman Sessler brought this up, can a hacker actually go and hack into a system, find the vulnerabilities and say, look, this is your vulnerabilities. What we want to do by stating that unauthorized and put in the way Ledge Council drafted it, that won't necessarily be an issue, because on line 12, we're dealing with unauthorized computer access. So we're already stating that these are individuals that have authorized access to a computer, and it's not hackers that are going to come and say, look, we found a vulnerability in your system and put it in writing. So what we want to do is protect, as we had witnesses on Monday, the researchers, the students, people that are there lawfully or with good intentions, so they won't be the ones that get caught up in a misdemeanor type of situation. We don't want a court to look at these individuals, them to be charged, and they're being charged, and that's not the legislative intent of this bill. So what I want to do is make sure we protect those college researchers, those individuals that are doing the right thing by disclosing and writing these vulnerabilities and not having them being subject to litigation.
All right, discussion on the amendment, Mr. Coomer.
Thank you, Mr. Chairman.
Proposed amendment, excuse me.
Thank you, Mr. Chairman. First of all, I'll just say that I'm opposed to the amendment, but I'd like to walk through each line. Obviously, lines 2 and 3 are not problematic. That's the language we have in the bill now. Line 4 is problematic. This is by any individual who's acting within the scope of his or her employment. The problem is that limits the exception to people who are employees of another. So an independent contractor, students, as Representative Bodie mentioned, or others who are doing this work independently are unprotected. if you accept this language. So I think that is very problematic in the sense that it's a way to catch people, not intended to, but I think it's a way that you'll catch people who are independent contractors not employed by someone else while they're doing this work. And then as regarding the third subsection, lines 5 and 6, the problem there is Chairman Setzler pointed out the other day, and we talked about extensively in the subcommittee, the problem is you're giving essentially a get-out-of-trouble-free card to someone who does something malicious and then simply says at some point, any time in the future, they say, well, I'm reporting this vulnerability in writing, and I'm doing it voluntarily, so you can't touch me. That would actually be counterintuitive to the underlying bill and to the underlying code section, because you a lot of times what's going to happen is somebody is going to report that there's a vulnerability, and oh, by the way, I'm exploiting that vulnerability by charging you money to give you control of your machine back. So we don't want to encourage that kind of behavior, and lines 5 and 6 do encourage that kind of behavior.
Mr. Chairman, I respond to the whip very respectfully to the whip. In regards to lines 5 and 6, if we had an individual that unlawfully, such as a hacker, come and say in writing that we have discovered these vulnerabilities, i.e. after the person has hacked the system, they still will be guilty of computer theft or computer trespass, which in this case, based on conversations on Monday, these are higher level offenses. These are felonies. So essentially, if they came in that direction or in that manner, the person is now going to be accused of a felony instead of a misdemeanor. So we still have the same essence of the bill of what we want to do here, but we're also going to protect those student researchers at the same time.
And if I may, Mr. Chairman, all of the kinds of activities you're talking about protecting, which I agree should be protected, are covered in the language currently in lines 17 through 19 in LC 298074S. It is my intention to protect exactly the same kind of activity you're talking about protecting. I think that the amendment goes further and protects bad actors as well as innocent actors, and that's why I'm opposed to the amendment.
Okay. Further discussion on the amendment, Mr. Setzler.
Hey, Mr. Chairman, I don't want to rehash too much ground that's been covered, but I would say to maybe expand upon what Whip Coomer said, and I want to do this with proportion. I'm saying it to both committee members and members of the public that are here, just for emphasis, that lines 5 and 6 of the amendment, if a person hacks a website and they're within your system, then an email to the person who you've hacked that says, I've hacked your system, I've got a vulnerability I want to show you, is, and I'm not trying to overstate this, this is exactly what it does. It's a get-out-of-jail-free card. So by virtue of sending somebody a written communication, they're then exempt from prosecution, and they simply need to prove that by preponderance of the evidence. I mean, I know it's not Representative Bodie's intention with that, but the effect of line 5 and 6 is that when you've, by a person, upon discovering a vulnerability, they've gotten into the network, they've gotten in without authorization and intentionally, simply by reporting such vulnerability in writing, they have an exemption. I mean, this creates a circumstance where people who are hacking, whether they've been caught or they think they may be getting caught, simply by virtue of in writing sending an email to the vulnerable person, your system has a vulnerability, you need to understand it. It's an automatic exemption by preponderance of the evidence. I just think I think it gets the purpose of the bill, Mr. Chairman. And I know that's not the gentleman's intention with the amendment.
Ms. Dickerson. Okay. Ms. Price. Okay. Okay. Mr. Bodie, do you want to proceed?
Yes. At
Okay.
this time, I want to move that we, as this committee, accept the amendment AM 292793.
Mr. Bodie moves on Amendment 292793 to the House substitute on SB 315. All in favor of the gentleman's gentleman's amendment signify by raising your hand. Opposed? The amendment fails. Are there any further amendments? Are there any further additional amendments? Ms. Kendrick? Okay,
I don't have an amendment, I just had a question.
sure.
On the back, the portion about venue on line 29 that talks about residence, is the usual language for residence in the code principal place of abode, or is residence defined elsewhere in the code? It's probably a lead counsel question, but just wondering.
Is that a question, Ms. Travis?
Or whoever
Did you have a
knows the
question for Ms.
answer-
Travis?
For whoever knows the answer to it.
Could you restate the question for Ms. Travis?
So on line 29, we're using residence, and I know usually in the code, the language is principal place of abode. Does residence have a different meaning than principal place of abode, or?
I have to tell you, I don't know.
Okay.
I recognize that both of those terms are used, and I don't have my handy dictionary to tell you what residence means according to our code.
Okay.
I will tell you that, I believe this language was supported and, asked for by the Attorney General's office.
Right, okay. Any further discussion? We have an underlying motion and a second on on a committee substitute, LC 298074S. Seeing none, all in favor say aye. Aye. Opposed?
No.
Chair is in doubt. All in favor of the underlying motion of do pass by substitute, please raise your hand. As amended, but it is amended, but we're saying by substitute for purposes of drafting. Opposed? And the motion is adopted. Thank you, Mr. Coomer. All right, let's move to Senate Bill 407. This is the administration's 2018 initiative on criminal justice reform. I know Senator Strickland is here. Is Mr. Miller here as well? And or a coalition of the willing, whoever's willing to come forward. You know? All right. So, Mr. Miller, let me ask you just to briefly run through the changes. These are changes just to set the table for members of the committee that have been negotiated between the committee and the administration. We have struck agreement and consensus on the issues. And
With respect to the underlying, the existing bill prior and what's adjusted, is that,
just the substitute that we have in front of you, this represents, you know, a consensus document.
okay?
Am I characterizing that correctly?
Yes,
Okay,
yes, yeah.
thank you.
Yeah.
I just want to make sure we're on the same page.
I will defer to the chair on some of the changes that have been made in section 1-1, just for a brief explanation.
I'll do that right now. There are, in 1-1, this is essentially House Bill 15, which was the e-filing bill that I think we passed ages ago, that has been the subject of debate between the two bodies. A lot of back and forth. There was a request by the author and by the House leadership that we would go ahead and include that in this bill as a vehicle to go ahead and move that issue. The administration graciously agreed to allow e-filing / HB 15 to catch a ride on 407, and that's what that reflects. Just want to make sure the committee is aware of it, but this is subject matter the House voted on a while ago.
With respect to additional changes, I believe the first one we come across would be on page 11, and this is working off of 2980-103 ECS, related to arrest by citation, which was in this bill and part of the sort of essence of the criminal justice reform package this year, but it's simply to clarify what I think was the intent all along with respect to requiring a actual arrest and fingerprinting at the time for these 4 new offenses. So you'll see on line 354, I believe right there is where it sort of begins the new substantive change. When an arrest is made for such an offense prior to releasing the accused on citation, the arresting law enforcement officer shall review the accused criminal record as is on file, and basically a GCIC run, and then ensure that the accused's fingerprints are obtained. These are for the 4 offenses of misdemeanor criminal trespass, misdemeanor theft by shoplifting, misdemeanor refund fraud, and then misdemeanor possession of marijuana. Believe moving into section 2-4, point out, apologize, I think 2-4 remains virtually the same. Moving into page 15 and 16 is where we have some additional changes. Starting on line 553 on page 16, with respect to when the court may waive, modify, or convert fines and any fee imposed in connection with probation supervision or at the time of sentencing a fine. An adjustment has been made to clarify again what was the intent to say that statutory surcharges will remain the same. The judge would be required to impose a theoretical fine, and the surcharge based off of that fine would remain the same. There was some language that was in tension with that earlier in this section. I believe in the previous bill would have been somewhere around 539 through 541, but just to clarify that that remains the same. What has also changed in this is with respect to the judge's determination on when it's appropriate to waive, modify, or convert any fines or fees. Rather than providing a rebuttable presumption, which I will point out does exist for in the context of probation, where a judge can adjust fines, fees, and et cetera. And also in this bill, it only got you to a may waive. Instead, we are just saying that the judge should consider or shall consider whether the defendant is suffering a significant financial hardship by imposition of the fine or fee, and whether the defendant is indigent or has a permanent developmental disability, which is defined earlier in the bill. And this is consistent with measures that you all have passed in recent years that essentially state what a judge should look at in these sorts of instances.
Mr. Miller, can I ask you one question on that? And this is just a clarification. Part of the conversation was the fact that I think there's a general discussion about these statutory surcharges, and that really the approach needs to be in the future to take a very holistic view of all of them and to see how how that process is coming about. Has it gotten too weighty? What can be done? Just almost like the way we look at it at tax exemptions. We've talked about that for a long time. How we address that. It's the same thing. How do we go ahead and address statutory surcharges? So that issue is real, and I think it's relevant. But as opposed to allowing community service or the statutory surcharges to be converted into community service, that was sort of piecemeal the issue to a degree. I think so. There was an agreement to go ahead and leave the statutory surcharges alone, with the full and public recognition that we need to take a very broad 50,000-foot look at how we're dealing with that. With that in mind, I mean, on line 551, and this just may have been, if I'm not reading it correctly, that's certainly more than possible. On line 551, where we're talking about the community supervision officer may request that the court make all or any portion of a fine, and it adds statutory surcharge or any fee imposed with probation supervision. From the conversation that we just had, in order to be consistent in the bill, my sense is that we should strike statutory surcharge in 551. Is that consistent with our conversations? That may have just been,
I believe it is. This is really the first time I've been kind of drawn to this specific provision. I'm not sure if it was in our previous draft. But
I don't know either.
Yeah.
I don't recall either. I just know that if we're going to go ahead and uniformly not make statutory surcharges subject to conversion to community service, then we should go ahead and strike that provision. And council, would you agree?
So,
If your policy is you don't want for community service, then I agree.
so I believe in existing law, there's a provision related to statutory surcharges at a later in probation maybe, but with respect to this, I think that's accurate to review
Okay.
this.
So the proper, just for purposes of consistency, we should move at the appropriate time to strike the word statutory surcharge in line 51, 551. I just want to make sure that we have consensus on that with the administration.
I think you would need to also strike it on line 546 as well.
Okay.
I think you, with respect to this, I think those two strikes get us to that consistency.
Okay.
Right.
And counsel, you were saying about probation?
Well, if we waive it, if it's allowed to be converted in Title 42 later in the bill.
So I would say that I think in Title 42, there are some different policy considerations with respect to post-conviction. I think there's some existing law that we may have reworded, but I will defer to legislative counsel to some extent. But to the extent that last year in Senate Bill 174, defendants were be able to move off of probation, even if owing outstanding statutory surcharges. I don't want to walk back what was accomplished in previous years. So I think the distinction here is at the time of sentencing, which is what we're dealing with in this section, and then probation, which is a later section, if that makes sense.
Can you look at line 550?
Is that's so prior to or subsequent to sentencing and then following with probation? I believe that's elsewhere too in Title 42, is it not?
I think the 42.834G section ties us back to 1710.1 and they work together. I'm not site plan, so I don't know how to.
Can we just commit to work on that if we need to and make more changes between the two bodies versus doing it on the fly?
And where I would be coming from on that is just for purposes of sentencing, and to your point earlier about, I don't think it'd be appropriate for us to do anything that would walk back anything that was agreed to by the General Assembly last year in the context of probation.
Right.
But for purposes of sentencing here, I just want to make sure that we're maintaining our consistency in the substitute.
Sure, I agree with that.
So I think in order to go ahead and effectuate that, we'd want to go ahead and strike statutory surcharge on line 546 and 551. There may be other places in the substitute. I don't know.
Line 834 on page 24, that was the change that was made in the criminal justice reform last year, that's what I was referring to.
Okay.
So I would defer to legislative counsel on this, but to the extent that we strike in 1710.1 but leave 42.834, I believe it still leaves in place the intent from last year. The 1710.1 is really more of the process, if I'm correct, but.
My memory is that 42.8 tells the court you can look to do sentencing in the same way you do it in 1710.
Okay.
So if the the complete policy of the General Assembly is never to allow community service for surcharges, ever.
I think the question is surcharge conversion at the time of sentencing, as opposed to surcharge conversion at a later portion, because that's what was in previous bills. So to the extent that we had it previously in Title 42, there on that language starting at 834, and 1710.1 was not altered in this manner, I think that striking it, we're still on the same page there, I believe.
I think the other fix might be just to get rid of on line 50 or subsequent to sentencing. Because if you're just saying before, at the time of sentencing, you don't want to allow this conversion, that would fix it.
I think that makes sense, because you're talking about two different, basically you've got multiple references to the conversion in the code. 42 applies only to subsequent to sentencing in the probation context. 17 is at the time of sentencing, so I think that strike would, along with the surcharge strike, would accomplish that, I believe. And would be consistent with, I think, what was the intent of,
Yeah, the discussion really focused around the prior to.
right.
And the question is how to effectively deal with that now with the sub. Is it proper for let me ask councils, will we be complete or comprehensive in terms of striking it right now, or do we do better to take a larger look at it in the context of a floor amendment?
Well, I think you can get rid of statutory surcharge on line 546. On line 549, you get rid of or subsequent to sentencing. And on line 550, get rid of or subsequent to sentencing. I don't know. Yeah. Can I look a little further while you continue on with the bill?
Sure.
Mr. Chairman, if we decide to make those changes now, of course, I'll commit as this comes back to the Senate as well to look more into this if we need to. This thing's got a little ways to go, obviously, anyway.
Yeah, I mean, the intent would be to make sure that we're taking I mean, as a practical matter, I don't see it coming to the floor until Tuesday.
Right.
So we'd want to go ahead and take the time to make sure that we've got it just right.
So while I've got this in my head, my suggestion would be to strike subsequent to on line 549 and strike or subsequent to sentencing a community supervision officer on line 550, which would leave it as prior to sentencing, a defendant may request that the court make all or any portion of a fine or any portion of a fee imposed with connection to probation supervision be satisfied under the subsection that still preserves the Title 42 probation context. I will move on with the bill if that's what the chairman would allow, but I just wanted to, while
Yeah.
it's fresh in my mind, to throw that out there to the extent
Right.
that.
No, yeah, please. And I think just the practical thing to do would be to get through the bill now.
Yeah.
Just in terms of the two or three big areas of, not terribly big, but just the areas of changes.
Of adjustment, sure.
Or of adjustment, and then to the extent that we can go ahead and just identify those areas with council in the interim between now and Tuesday, we can certainly, cure it with a floor amendment. I just want to make sure we can certainly cure whatever needs to be cured with a floor amendment. I just want to make sure we're doing it in a comprehensive manner, that we're not missing anything. And we have the gift of time in order to go ahead and do that. Does that make sense?
Sure.
Okay, please continue. Thank you.
Okay. The next change would be in section 2-8, you see a reference to 35-3-7, which is the youthful offender statute for record sealing. Nothing has changed with respect to the requirements to be eligible for record sealing, but the part that we're making an adjustment there is consistent with what is in another portion of the bill, which says you go to the court you were convicted in to make that petition. So previously, we referenced Superior Court. The realization was not everything was done in Superior Court all the time. It could be in state court. So the filing of a civil petition in Superior Court to seal a record in state court was a little clunky. And so this was a reference that we missed in the first draft of this bill for the youthful offender statute. Mr. Chairman, I believe the next portion of the bill in section 2-11 relates to the disabled persons assistance, and it's kind of pervasive throughout that section. I would defer to the chair for the explanation there, if that's appropriate.
Yeah, there was some discussion after review in the last hearing about the disabled assistance and whether or not that, just from a purely policy perspective, if members were comfortable with that as community service. That in addition, as opposed to, in other words, it was looked at, or some of the discussion focused on how it wasn't necessarily community service it was doing and fulfilling duties usually within a family duties that were expected anyway, as opposed to serving the community. There was also a public safety concern in terms of disabled assistance. Well, would you have this individual, depending on who they are and what their record was, coming in and being assigned disabled assistance when in fact they were possibly not the best person for that job, and did that set up a public safety situation where the individual who was being assisted could end up being at risk? That caused some discomfort. That also, just as a secondary note, led to the conversation about educational advancement. And really, there was discussion regarding educational advancement and how, was that really community service or was that really personal development? I think in a purist view, educational advancement is personal development. But given the fact that, number one, courts are doing that now, it's a large part of sentencing, and it's been fairly effective over the course of years. And when I say effective, I mean it in terms of its effect on whether or not individuals will reoffend, become recidivists. My understanding is that the data demonstrates that educational advancement reduces that number. So while it can be certainly argued that educational advancement is not community service, but it is personal development, it is at the very least having a positive effect on the reoffend numbers that we're seeing. And as a practical matter, it's being done right now. Getting a GED, getting whatever the certification may be for a professional licensing is part of sentencing that judges are imposing right now, and it seems to be working. So under the category, if it ain't broke, don't fix it.
I would echo the chair's statements there, and also to point out there's a significant body of evidence with respect to lowered recidivism rates with educational advancement. And, to the extent that that's a goal of the Reform Council, of my boss, and of the General Assembly, which I believe it is, I think this moves a step forward as well. So. Then I believe the next, moving along in the bill to the next significant adjustment will be found in Part 4, I believe. You have the TCS or the PD&P deal. So in Part 4, Section 4-5, you'll see 161360. This is in relation to the prescription drug monitoring program. This is actually a bill that had been presented in the House previously, has passed out overwhelmingly, and is to enable the ability of sharing this prescription drug monitoring program with other state agencies and with other states. To enforce and continue keeping a monitor on the ongoing opioid crisis here in this state. So that's the intent that you see in 161360. There is one slight adjustment to House Bill 782, which was presented by Representative Rhodes, and that comes at the request of the U.S. Attorney's Office with respect to making sure that the warrant requirements we're requiring of the federal government actually match up to what they require to access this sort of information in their prosecutions. The next adjustment is found in Part 5 of the bill and relates to the powers of arrest for Technical College System of Georgia Police. This simply aligns Technical College System of Georgia with the University System of Georgia and intends to put them all on the same page. We would make one request here from the committee, from the substitute in front of the committee, would be to adjust on line 1251, strike yards and insert feet to that portion. I believe that's a interest of several members on that adjustment. I think that covers all the significant changes in the bill, unless I'm missing anything that we discussed, Mr. Chairman.
I don't think so. Let me open it up for questions for members on any of the changes. Mr. Setzler, I know you had a question from before. Push the, yep.
Thank you, Mr. Chairman. Couple questions across different sections. Is that okay for me to walk through a couple,
Sure,
or would you rather
sure.
just limit it to one?
Sure.
I'm going to go in reverse order. Where in Section 4 of the bill are we addressing the issue of the prescription drug monitoring program and changing the standards by which we share information and also warrants are issued for inquiries?
They'll be in section 4-5.
4-5. Okay. I just, as I survey through this, I wanted to understand what changes we're making specifically. I know, in 2011, when PDMP passed, after having failed the two previous sessions because of concerns about privacy concerns, I know we, I think we felt like by 2011 something needed to be done, and this committee had, I think there were 4 subcommittee hearings and 2 full committee hearings on it to get it just right. I think the concern is I think we're in a day where, Mr. Chairman, just by my estimate, that the idea of sharing across states is probably recognized as being more meaningful now than perhaps it was in 2011 vis-a-vis opioids.
Mm-hmm.
But I do think one thing that this committee was resolute on was the question of administrative executive subpoenas. Federal law enforcement has way more power to do that generally than we do here. Could we talk in very plain terms about what changes to subpoenas outside of judicial order are contemplated in this change?
So with respect to the state law enforcement subpoena power, that remains the same subpoena power that they would have in the state otherwise. With respect to federal law enforcement subpoena power, really there was some improper, I think, code at the beginning, which referenced an entire, or actually 2 entire titles of the U.S. Code, Title 18 and Title 21. So the intent was to, and this was to allow the subpoena as allowed by federal law, the issuance of a search warrant or a grand jury subpoena as allowed by federal law, or as an administrative subpoena or a civil investigative demand as allowed by federal law.
And I just say, just for members of the committee, that was really one of the issues in 2011 that was just very clearly addressed. That it's just a policy question for the committee, Mr. Chairman. But if you look at the ability to issue administrative subpoenas allowable by federal law, I don't want to overstate the case, but it is far broader than what we have here at the state level. And I know that was something that was definitively, the door was closed on that definitively in 2011 for a very particular reason, because the federal administrative subpoena power was so broad. So I'm not sure that I understand every detail of that, other than because it's been 7 years now, 6 years, 7 years. I think upon great deliberation, that door was closed back then to make sure that the process was more consistent with Georgia. And I don't know that this does that, Mr. Chairman. I'm just sharing that as a concern. I can delve into the details as appropriate if there's gonna be another effort on this between now and Tuesday. I remember Whip Coomer and the Well on this bill talking about, very, very careful concerns about this balance. And is there a concern if we were to give the federal powers in a way that's consistent with state powers, is there a concern with that?
In a way that's consistent, I'm not sure I'm understanding the question
Okay, if we took the administrative subpoena powers under state law and had federal law follow those same requirements, is there an issue with that as a structure?
So I will really defer to the committee on that language as far as the federal ability to subpoena. This was at the request of a former member of this House through a member of this committee to make this adjustment. So I will defer to the will of the committee and to the chair and the vice chair as to some of this, really.
And I ask, Mr. Chairman, it's a legitimate question. I don't have the answer to it right now. I know that was a major policy debate that and I don't want to overstate my case, but it's virtually at will that a federal law enforcement agency can get access to this based on their rules. And I just think it's something we need to consider with eyes wide open. Mr. Chairman.
I don't disagree. I mean, and that goes to the integrity of their process and just what they're going to request and in what form and how often. My sense from the request of the U.S. Attorney's Office came given the, I don't know if Mr. Miller used the word clunkiness, but just the procedural, potential procedural difficulty that comes in the context of a grand jury subpoena and the secrecy that's involved there. I think it was more of the request from that office came more as a, I don't know if streamlining is the word, but more of just an ease of use in order to expedite their business as opposed to going through the grand jury process without minimizing the importance of it at all. And that was the sense that I got from my communications with that office and understanding the sensitivity of it, but just from a pure practical doing business standpoint and the job that they have to do in trying to strike that balance. I'm going to call on Mr. Coomer and then the Vice Chair.
Thank you, Mr. Chairman. I have just two questions I think that may be instructive or helpful. First of all, Mr. Miller, isn't it true that administrative subpoenas and civil investigative demands are terms that are fleshed out and understood within the context of 18 U.S.C. already?
Yes, I believe that's the case.
And then secondly, as I understand, this specific language was requested by the U.S. Attorney's Office for the Northern District of Georgia, Mr. B.J. Pack, who was in fact a member of this committee when we addressed this issue the first time around, and who also shared many of the same concerns that Chairman Setzler and I shared with regard to individual privacy and security of that information. Is that correct?
I can confirm the request came from him. I'll defer to you on the details of the committee testimony.
Yeah, you were still in secondary school at the time. So. Thank you. So my point in those two questions is I don't think we are substantially widening the door. I do acknowledge that we are giving more flexibility to the federal government, federal prosecutors in particular, to request this information. But I'm satisfied that the safeguards exist so that we're not going to run into the kinds of problems that I anticipated in the past, and frankly that I still am concerned about with regard to state sharing, that I think you have addressed appropriately here.
Yeah, as I recall, it's all coming back to the surface, back from what were protracted debates back in those days on this particular issue, and I'm glad that we did. But it really, if I recall correctly, which does not minimize any concern, but the state to state, I think for those of us who were around then, that was the bulk of the concern then. Not exclusively, but certainly it was at the top of the list. Let me call the Vice Chair, and then I'll bounce back to Mr. Setzler.
Thank you, and thank you, Mr. Chairman. I'll just share a clarification that I received when I stepped down to the table. On line 1251, which is the part 5-1, this is dealing with the technical colleges of Georgia and campus police jurisdiction. and the proposed, what will, I guess, eventually be a proposed amendment of changing 500 yards to feet. Obviously, I don't know if everyone on the panel has followed this, but this has been, there's been a debate in the Public Safety Committee relating to 500 feet versus yard as it relates to the University System of Georgia. This this has only has application to the Technical College of System of Georgia. So my understanding is that the deal or compromise that was reached on the other bill that affects USG is not the same as this. And I personally had interest in that, and am very comfortable with what the committee resolved on in that. Further, I have no issue with this technical college provision changing it to 500 feet. So.
Mr. Sessler, did you want to close the loop on the PDMP issue?
Mr. Chairman, I just, if there's going to be further study on this bill between now and next week, I just raised that as an issue. I want us to proceed eyes wide open on things. I do think the context of PDMP is different today in 2018 than it was in 2011. Some things I think are timeless. I think some things evolve. I think that the view of the use of PDMP as an enforcement mechanism in the context of opioid abuse, I think, is different today. But I think I would caution this committee, maybe in any other context, this ought to be a stop for us, just in terms of the ability to allow administrative subpoenas. I know we addressed this last year in SB1. Very different subject matter, and I think we addressed it appropriately last year. I did, Mr. Chairman, do have two other questions in the
Sure.
bill.
Well, what I can tell you is that it's the chair's intention to accept a motion today. That doesn't preclude ongoing conversation. We're going to go ahead and make sure we've cleaned up on statutory surcharges between now and the time it's on the floor, assumedly next Tuesday. So we want to make sure we get it right, and then to have that consistency. Again, on statutory surcharge, I just don't want to have as I'm heading out the door, as others are heading out the door, as the governor's heading out the door, we want to go ahead and have a funding issue as it relates to the statutory surcharges. That's the practical issue that goes along with that, since we're going to go and take a look at that to make sure we're consistent. While we have that gift of time, we can certainly continue that conversation with the administration. We'd like to have a consensus bill for sure. But we'll go ahead and use that time, to our advantage to make sure the bill is as tight as it can be.
Mr. I just don't want my great personal affection for our U.S. Attorney to cloud the issue that I think Georgia needs to maintain a much tighter and more, what I believe, more appropriate standard on administrative subpoenas than what is in current federal law.
Well, like so many issues, we have to think about it's not about now. It's about 25 years from now. And that being said, if there was ever a person I'd have complete 150% faith in on that issue and any other issue, it's our current U.S. Attorney for the Northern District of Georgia, B.J. Pack. That being said, that doesn't preclude legitimate concerns from being discussed, and the question really, it will come down to a policy decision on how comfortable are we. I'm personally comfortable, but I'm only speaking for myself, and I don't dare do anything more beyond that. Ms. Silcox.
We did have a bill in the Health Committee this year that was a cleanup on some of the language in the administration of the PDMP in physicians' offices, and I was just curious if y'all had looked at that at all in drafting this.
I may be incorrect, but I believe that may have been House Bill 782, which is the same provision.
It is the same, okay.
Yes.
I was just making sure, because I would want it to be consistent with that, so
yes.
I appreciate you checking that, thank you.
Did you have anything else? Okay. All right, any further questions for Mr. Miller, for the chair? Senator Strickland? Mr. Sessler?
And Mr. Chairman, I did have two other points.
Oh, I'm sorry, you did say that before, I apologize.
Lines 349 through 358 of the bill.
Say again?
Lines 349 through 358. Just dealing with law enforcement officer may arrest a person and issue a citation in lieu of actual arrest.
Let me address that if I could. the concern there, the way the bill had come to us, there was a concern regarding what it's essentially would have been ticket and release. It's no different than a traffic ticket, which I don't think in and of itself is problematic, but the concern had to do with who are we dealing with, and for the way it was written at the time was an individual could be ticketed and released on those particular 4 charges. We don't know if that's a correct ID. There are a lot of things that that the law enforcement officer in his or her discretion at that time would not have known about that individual. So after, again, conversation within the committee, some concerns expressed both in the committee and through interested parties, the whole goal of that section, and the council will go ahead, and the executive council will go ahead and correct me if I'm wrong, the whole goal of that section really was to make sure on those 4 charges that the individual would not be stuck in a local jail because of their inability to make bond. That's really what I understood to be the real policy goal, which, again, just speaking for the chair, I had no problem with. My interest was in making sure that law enforcement had all the information that was possibly accessible before they made the decision in their discretion as to whether or not to ticket and release. And so that's why we went ahead, and the GCIC is not run until the fingerprint process occurs. So what we wanted to do was to make sure that that occurred on the front end, so that the fingerprint process occurs. That individual, just from a law enforcement experience standpoint, goes through that process of getting fingerprinted. And if they've spent a lot of time at the local hotel, ours is in Marietta, others are in other county seats, across the state, then they know what that process is like. But for the new offender or the newer offender, that's an experience they need to have in order to go ahead and make sure that, they think about what they're doing and how they've ended up. It also practically speaking gave law enforcement the ability, if they're going to print them on the front end, run the GCIC, run the NCIC, know exactly who they've got, what this person's history is, and so they can make a fully informed decision. Do I ticket this person and let them go or not? That's their discretion. That's their discretion. I just wanted them to go ahead and make sure that they made that decision with all the information. This also, just from a practical standpoint, I think it cured the concern that was expressed by the Sheriff's Association in the bill that came over from the Senate, in that, well, when's the print going to happen? Who's going to pick the person up? Is it going to happen when they make their court appearance? If so, how's that going to happen? Is it going to happen in the courtroom? Are they going to have to go to the jail? Who's transporting? Logistical resource issues. What this did also, it wasn't the primary intent, I want to be clear about that, but it had the effect of clearing up that problem. They're going to go down, get printed, get processed. If they want to go get the NCIC run, get the GCIC run. If they're going to get released, fine, ticketed, released, but they do so with, law enforcement does so with eyes wide open. And it takes care of the Sheriff's Association issue at the same time.
So Mr. Chairman, you believe this language creates a circumstance where the person will be detained, printed, and go through the whole process?
It mandates it. It mandates it.
And
Shall.
yeah. And that was the intent all along, if I may, Mr. Chairman, to say that we at no point intended for it to just simply be a
Right.
simple ticket and release, but to mandate this process and to clarify that that has to occur at the time of the issuance of the citation, or at the front end, as Chairman pointed out.
Right, and it's not the chair's intent to characterize the administration as wanting to have done that. It's just that the practical realities of the timeline of what happens at that moment right after that individual was caught stealing a $450 television out of the Costco at Cumberland Mall. Law enforcement, CCPD shows up. What then? What happens right there and then? Well, right there and then, if they can produce an ID, they produce an ID. They're going to go ahead and run them on the onboard computer. But there's only so much information the onboard's going to have. The only way they can really and truly confirm ID is to go ahead and run the print. They go ahead and run them down and get the print, run the GCIC, get the NCIC. Okay, this is just not that big a deal. This guy does not have a history as long as your leg. We're going to exercise our discretion. We're going to go ahead and take it and release. Fine, as long as they've got all the information necessary. But it mandates and ensure the
I think on line 355, shall review the accused criminal record as is on file.
Right.
You know, just out of an abundance of caution, in looking at it in line 358, I'd like to add the words on 358 and ensure that the accused fingerprints are obtained prior to release.
That's on line 354.
Yep.
Prior to- I'm sorry.
release.
On the front end, I'm sorry. Make sense?
And if I may, to also point out that, you know, this whole citation process is not requiring any jurisdiction or any law enforcement officer to issue a citation. But if you do choose to go that route, you shall bring the person in for a fingerprinting, run the GCIC, et cetera.
Mr. Chairman, I guess I just asked, I'm just concerned, I mean, the threshold on this shoplifting, and you know, the code contemplates $300 in some places, in other places you're looking at I think about a felony being $1,500. Is this a $300 or under offense?
I believe it's 5. When we went ahead and during the governor's first term, I carried the first 2 heavy lifts on criminal justice reform, and I'm still not walking upright, but I'm walking. And we updated those thresholds. Many of the theft thresholds were raised to approximately $1,500. We did purposefully lower the shoplifting threshold, and I believe it's 500 now. They're all misdemeanors. And that came in conjunction with discussions with the Retail Federation and the administration. And so you're talking $500 is the threshold on that. That's why I alluded to the example of the $450 television out of the Costco at Cumberland.
And on the marijuana charge, it's less than 1 ounce, is that the threshold?
Yes.
I guess, Mr. Chairman, that probably gives me the most pause. And I say this, and I guess out of both sides of my mouth, there's the issue of equal application of justice. I mean, if this is what kind of judgment calls are people making? Are we empowering law enforcement to treat one person one way and another? That gives me pause. I'm sure that's been considered. But it also gives me pause if you have less than an ounce of marijuana and you're selling dime bags to high school kids, then it just makes me nervous about what the unintended consequence may be.
Well, that ends up being possession with intent to distribute,
I get that,
and
but-
selling as
Does
opposed
not
to just
include
straight possession.
with intent, only straight possession.
Right.
I get it, but possession of 0.85 ounces of marijuana, that's a lot of pot. And I mean, in the minds of some, it's not a bust that's gonna produce it's gonna make a headline.
No, I mean, it's a Schedule I controlled substance at the end of the day, and I think that needs to be said out loud, and no one is saying otherwise. It's just a question of, the charge is still the charge. It still is what it is. It's still an arrest. There's still a required court date. They still have to show, or else there's a warrant issue for their arrest. So there's nothing, it's not, as I see it, the real change comes in the ticket and release. They still have to be processed, and they still have to be printed. So that's the comfort, and I had the exact same concern the gentleman has. If the discomfort for me would have been had they not had to go get printed, not just from a public safety standpoint, and then from are we de facto reducing the seriousness of this crime, really? I think we cure that by ensuring that they're processed and they're printed at the time. And then the officer makes his or her decision, at that time. Same charge, same penalty, same everything. It's just a question of, do they have to go ahead and make bond or not? That's the practical difference. Mr. Miller, do you agree with that? I just wanted to, I see the practical difference, the only practical difference in the citation piece as, do they have to go ahead and potentially there's the potential they don't have to go ahead and sit there and make bond, but everything else stays the same.
That's correct. Yes, sir.
And from a public safety standpoint, we've run them. We've run them through the system to make sure we know who they are, what their background is, so that the officer can make that educated decision. I shared the gentleman's exact concern. Ms. Price.
Yeah, thank you for that line of logic, because that was exactly where I was going with the reduction in the number of instances where bond would be obtained. Is that an issue?
I'm sorry, the reduction of instances being an issue in what way?
Just that process would be bypassed.
I don't believe so. That was what the council sort of set out to look at misdemeanor bail, and the ways in which we could preserve the process and the public safety aspects of bond while ensuring that lower level, low risk offenders are not sitting in jail simply because they cannot afford a bond. I would point the committee lower in that section to say that, if the jurisdiction exercises the discretion in issuing these citations, the presumption is changed to where a judge shall issue a bench warrant for the person to return as well, as opposed to may issue a bench warrant. And I should say that all these portions of the bail and bond process are subject to extensive discussion with myself, with our bill sponsors, with members of the bond industry, and also with local law enforcement. And this is kind of where we came to as far as a consensus of what is the approachable and properly approachable manner. So I would draw a distinction between what we're doing here and what may be occurring in other jurisdictions in terms of quote-unquote bail reform.
Yeah, my concern is that they would or wouldn't show up at their hearing.
This is also already being done by our magistrate courts, already have this authority. This is nothing new for them. And my understanding as well, we're codifying a lot of the current practices in this area as well. And it does have the may in there, there's a flexibility there. And so an officer could look at case by case, but this is simply, I don't even know if these people are getting, half the time getting bail now anyway, other than signing, saying they're gonna return. That's what you do with the citation. So they're still gonna be brought in, fingerprinted, and go through the same process. It's just whether or not the extra step of a bail, they're sitting in jail waiting for a hearing to get a bond, whether or not we're gonna have someone that gets into our criminal justice system because of financial issues, because of one offense like this. I think giving this flexibility is a positive thing for our law enforcement.
To also indicate in the context of misdemeanors, you have a statutory right to bond. So the dispositive question doesn't become if you get bond or if you are released. It becomes how much you have to pay. The question for the General Assembly and the question the council considered is what are the policy considerations of that, and what policy statement do we want to make with that presumption?
And if I may,
Sure.
there was the previous LC number. There, I did have some questions, and I can't find the actual lineup of lines now. The questions that I had on various lines were related to the amounts and the way that was determined of a person, financial status, et cetera. And I'm not a lawyer, but how much are we allowed to delve into someone's financial situation to make that determination?
The court has fairly broad discretion in setting bond. I would point out to you that the reason that consideration was put into this bill would be on the basis of litigation ongoing in our federal courts right now, trying to invalidate the entire system of misdemeanor bond and bail on the basis that the judge at the time did not consider as a factor the defendant's financial ability to pay. And it goes directly to due process concerns, excessive bail issues in the Constitution, and simply says that a $500 bond is different for one individual than it may be from another. And perhaps the equivalent is something different for another individual. So nothing here ties the judge's hands to require one way or the other that a judge lower the bond, that a judge release on own recognizance, that a judge release on a steep bond. It simply states a judge shall consider at the time of setting the bond the defendant's ability to pay in some form.
And there are no maximums or minimums?
No. So there are existing bond schedules, I will tell you that. So this is all departing on what is the schedule. So each circuit has a bond schedule of what they've set for certain offenses. So this would be a departing from the schedule if the judge decides to, which the judge has the power to do so now. Just to be very clear, the judge has the power to do so now. So this is really just putting in those sort of considerations of maybe what the judge should consider.
If I may, where are those lines? Because in the previous one, it was line 554, but I don't know where it is in today's version.
The bail, look at line 404. What they shall consider. Page 12 of the new substitute.
Yes, in 404 to 410.
It gives the judge, retains their discretion. It's, at the end of the day, shall consider. Well, the court makes a decision.
It seemed like the other one had broader language or more, didn't just say shall consider, so maybe this is an improvement.
No, the previous version did
It's the
not.
same.
It was the same. It was very clear to not dictate to the court as to what they shall do. It was guidance. It was guidance then. It's guidance now in this version as well. But what you may be referring to is on line 391, 394, the court shall not impose excessive bail.
Yeah, which is simply a federal constitution requirement. And then if you see, as you continue on those lines, shall impose the conditions reasonably necessary to ensure attendance, protect the safety of the person and the public given the totality of the circumstances. This is a reiteration of the purposes of bail.
Mr. Tremp.
Thank you, Mr. Chairman. With respect to section 4.2, beginning at lines 1107, in the bill, in the subsection B that is at 1113, looks like this has a lot of language. Frankly, a lot of these things are antiquated articles, like an adding machine, typewriter. And my suggestion, understanding that this is a work in progress, though it's presently a felony under the law without this bill, would be that we incorporate some type of language similar to what we have in theft, 16.812, with respect to the monetary amounts, so that someone who has an adding machine with a filed off serial number isn't subject to a felony. It seems like, you know, that ought to be a misdemeanor and ought to be an easy change. I don't have any issue with and think it's appropriate with respect to the alternate identification on the firearm for the higher provision, but we've already made that policy determination with respect to theft, and you know, that's something that if the sponsors and the governor's office was open to, I think would be a good change to the bill on that.
I think with respect to the that suggested change, I really can't comment much as to the in this bill, but I think it's a considered policy position. With respect to this bill, that would be an alteration from existing law that we weren't intending to address, and I would certainly be willing to consider that on its own merits to the extent that it's offered as a separate bill. But you know, I don't know enough about altered articles and serial numbers on them to really comment. I don't believe that, but.
Mr. Leader, I agree. I think we ought to have some hearings on that issue. I was laughing at Watch Case being in here, and maybe we ought to commit next year into addressing this code section and getting some feedback as to what needs to be listed there for prosecutors. We have not done that. It'd be the first time we discuss it right now through this process.
And Mr. Chairman, I would just say I think that it is it's probably something that wasn't looked at, obviously. But you know, the question I would have is, I mean, certainly it's not it shouldn't be the policy position of the state with a filed off $25 watch ought to be subject to a 1 to 5 felony.
Yeah.
Hopefully not.
Vice Chair. Okay. Mr. Coomer.
Just following on the leader's point, I don't think we need to take too lightly the idea of people scratching off serial numbers from comptometers, because that is a big issue in Georgia. We don't want to, we don't want to walk away from the ability to prosecute people who've scratched off serial numbers from comptometers. And as soon as I know what a comptometer is, I'll tell you.
All right, I'll say it. What's a comptometer?
I don't know what it is. I was about to ask Carrie.
I'll say it.
Or a dictaphone.
I was actually going to say, if the minority leader could tell me what a comptometer was, I'd support his amendment.
I'm glad I'm not the only one. He doesn't know. For the record. All right. Ms. Price, did you have anything else?
Yes, back
Yes,
to
ma'am.
lines 404 and to 410, where it says the court shall consider all those very, very detailed listings of the way to determine someone's financial status. And I'm wondering how much time it would take to find that out in somebody who, not only had limited means, but somebody who had considerable means, and how onerous that would be, and how much privacy you would forego, because the court is required to consider jointly controlled assets, your income, financial obligations, i.e., whatever loans or leveraged monies one would have, et cetera, et cetera. It sounds like to exhaustively meet that requirement, it would take a long time, and therefore perhaps somebody of greater means might be treated less fairly than someone of lesser means.
If I may, Mr. Chairman, that is something that is already being done by our judges. This is codifying what the Constitution requires as far as due process. And the judges also, Superior Court judges, have weighed in on this legislation and have signed off on this legislation and been part of this whole discussion. So it's not something, while it sounds like it's something that will require a big undertaking, it's something they must already constitutionally do now, according to the courts. And we're trying to codify that practice to have uniformity in our state. And there are some judges here that might could confirm this, but this is something that they have seen and agree is something that ought to be in the bill as well.
So they're currently acting outside the law, is that what you're saying?
No, they're following the Constitution now if they do this.
It's just not codified
Right,
in
it's
our
not codified.
statutes. So, and also say, and I regret, I'm unsure if I provided the chair with the letter, but this bill is supported by all classes of judges from the Judicial Council who have considered this language and are comfortable with it.
Ms. Dickerson?
Thank you, Mr. Chairman. Is it on?
Mm-hmm.
I don't want to date myself, but a comptometer is an old-fashioned adding machine.
We just looked it up.
I mean, I used to use one. That's what I'm saying. In the old days,
I don't think I would have said that second part.
That's okay. I still look young.
Yes, ma'am. Mr. Setzler.
Thank you, Mr. Chairman. I just following this line of thinking, I unfortunately am old enough to know what a comptometer was. I'm not sure that's a market distinction or not, but I do think to the minority leader's question, if we've got an item that there's no defined dollar threshold, and let me say, if there is a defined dollar threshold that applies here, that I don't see in the plain text of the bill, then I'm certainly open to that suggestion. But I mean, if it's a felony 1 to 5 to alter the serial number of an item that itself has an underlying value of $150, like a vacuum cleaner, I don't know why, if stealing the vacuum cleaner outright is a misdemeanor, but changing the serial number would be a felony in 1 to 5. To me, Mr. Chairman, it seems that you'd think about defining a value threshold. I mean, if stealing something of $1,400, not in a shoplifting setting, but in a I guess a theft setting, is less than the $1,500 threshold. Say it's a $1,400 item. If that's a misdemeanor, then one would think it would, changing the serial number or messing with the serial number, should the threshold be $5,000? Should the threshold be $1,500? But I can't imagine why it would be less than $1,500 if we're trying to just track the logic of this. I mean, it's when you think about circumstances in which you have a crime and then a criminal attempt, just changing the serial number would seem to be on par with something like a criminal attempt, something less than the threshold itself. I don't know. As I think about this, maybe we would be well advised to think about a dollar threshold that might be higher than 1,500 so that there's clarity around it.
I don't discount what the gentleman said and what the minority leader said either. I think just for practical purposes right now, I think that would come under the category of if there is a proposed change, we can take a look at it in the context of Tuesday, but I would like to get consensus with the administration and the committee in general to get, to be at peace with that rather than altering, the substitute right now. I think just for practical purposes.
We just dealt with firearms in this section.
Only adjusted the punishment by firearms, and I realize that Representative's question goes to the existing state of law, and in the interest of not creating unintended consequences, I would suggest that I think it's a matter that probably needs a little more fleshing out that we did not consider, frankly, because we were focused on firearms with altered serial numbers.
This would be the only hearing we would have on this whole subject. You have to think about it that way too. But I do agree. When I first saw the bill, this terminology, I didn't know what this stuff was either. But we didn't address this in the bill. We just addressed the firearms, and I think it's something we ought to consider next year. But we will not have time to have any other hearings other than this on this whole subject right now.
I tend to agree. I mean, I think it's the type of thing that begs for a bill to go in like on day 39, 40 to sit over the interim and be a discussion point and to act, quickly or relatively quickly, next session to gain consensus on it. I'd be hesitant about this particular bill and the administration's point about how that was not specifically addressed in any version of their bill, I think is well taken. Vice Chair, you got the last word if you want it. Your button is pushed. None? Okay. All right, with that, what I'd like to do is to proceed to a motion again, but prior to accepting the motion, I'll just make clear that on the statutory surcharge piece, because I know there are interested parties who are interested in that issue. We'll look at that between now and Tuesday and make sure that we've got that cleaned up to the extent that we can. I know that there's been some discussion on that, and we're not ignoring that for sure. Ms. Ballinger moves due pass of SB 407 by substitute LC 298103-ECS. Is there a second?
Second.
Second by the Vice Chair. Are there any amendments? Mr. Trammell.
Thank you, Mr. Chairman. There is an amendment in the package AM 292782. This is an amendment that Representative Oliver has discussed with members of the committee. And Mr. Chair, I would ask the chair and the committee's indulgence if Representative Oliver might be able to speak to the amendment.
This is the first time I'm seeing this amendment. And I had no discussions with anyone about it to this point. I think protocol dictates that a member of the committee will go ahead and speak to the amendment. With all due respect to any member of the House, I think it would be, I'm not sure that would be proper, but any member can put forward an amendment if they wish to. Mr. Leader, if you'd like to.
Well, Mr. Chairman, with due respect, I'm happy to offer the amendment, but if she has an opportunity, perhaps the amendment would not be offered.
Say again?
I'm happy to offer if we want to move the amendment, but if she has an opportunity to speak, it might shed some light on, where the conversation as to why the amendment, and there may not be the need for the amendment.
All right. In deference to Representative Oliver, we'll recognize you at the podium to speak to the potential Trammell amendment.
Thank you, Mr. Chair. I did come to you a couple of times asking about 407 and the issue of shackling.
Oh, you asked me about 407. You didn't ask me about shackling, just to be clear.
I have spoken with many of members of this committee about the issue of shackling that was brought to me by a member of the criminal Justice Reform Commission, Judge Teskey. I was a former member of the commission myself with Judge Teskey, and he asked me to introduce a bill that presumptively stated offenders in juvenile court would not be shackled, but may be shackled pursuant to a number of different procedures. And based on that request and the Council of Juvenile Court Judges Executives Committee determination that they wish to proceed on an anti-shackling policy, I introduced House Bill 966, which is signed by Republicans and Democrats, and a number of you on this committee signed it. When that bill did not go forward, I saw an opportunity to present the discussion of shackling, which had been part of the Criminal Justice Reform Commission, in the form of Amendment 292782, simply to say that this is the only significance of the amendment, ask the Council of Juvenile Court Judges to issue their own rule on shackling, since the National Council had taken a position and their executive committee had taken an executive position. I wanted to move this issue forward simply by giving them a timetable of a year to adopt a rule, and that was the purpose of the amendment. I talked with floor leaders and other, Mr. Coomer, numerous times about this issue, and was told this morning by the governor's office that they didn't wish this amendment to be considered in this bill. I'm respectful of that decision, and I won't ask Mr. Trammell to offer this amendment, which unfortunately would take a bipartisan discussion into perhaps a partisan discussion, which I wish to avoid. This is a serious issue. It's a national issue. I think it is part of the criminal justice reform discussions, and I would ask each of you to consider whether or not your juvenile court judge has already adopted a rule about anti-shackling of children in court or not. Many courts have, and I'd like the council to issue a rule on that so they can decide what policy they want instead of it come through a bill like 966. Thank you, Mr. Chairman, for your indulgence. I appreciate it.
No, I appreciate Representative Oliver's comments and her history and service on this campus at this Capitol. It's a long-term commitment, and the sincerity and authentic nature of her concerns and the issues that she has spoken to over the years have been very consistent and sincere. Again, I think on the issue itself, I think we do well to have any council act within its own body first to get some consensus. If they can go ahead and effectuate that through a rule, whether one agrees or disagrees with that, that's usually better than 236 of us mandating that within a court setting. Sometimes that's necessary, but we try to err on the side. I know we agree that we try to err on the side of not doing that. Number one, because we know what we know what we don't know, and that's before we even get into the conversation of separation of powers and the judicial branch is a co-equal branch of government that, to the extent that it can and should make its own rules for that kind of internal, essentially procedural, but also public safety issue.
So thank you, Mr. Chairman. It sounds like we agree. Hopefully the council will hear your views anyway and go forward with issue a rule on this issue.
The one thing I would say, just not to argue against myself or the lady, is the fact that to the extent that we can go ahead and maintain judicial discretion, we do better always.
Yes, sir.
To do that, provided that public safety is not compromised.
Yes,
and
sir.
that's the balance. I mean,
And
to me, that's the balance.
That was what 966 talked about based on national models and existing court rules throughout Georgia. What are the circumstances when it must be addressed affirmatively? But I'm glad we agree that the Council of Juvenile Court Judges should be the first entity that issues a rule on this matter.
It should be the first word, and then we can go ahead and take notice of that, or the General Assembly can take notice of that and then potentially act accordingly or not, depending.
Thank you.
Thank you. I appreciate the lady very, very much. With that, we have an underlying motion and a second. Are there any amendments? Are there any amendments? Seeing none, all in favor?
Mr. Chairman.
Mr. Strickland.
I think someone was going to offer an amendment on line 1251, I believe. I'm no longer on the committee, but there might be someone that could offer it about changing yards to feet.
Yeah.
if possible.
Mr. Strickland, we'll go ahead and quickly,
Okay, thank you.
we'll quickly swear you in as a member of the committee.
Thank you, I appreciate that. I'll offer amendment on line 1251.
Whatever it takes. Let me recognize the vice chair to propose the amendment.
Thank you, Mr. Chair. I would like to offer an amendment on line 1251. The last word in that sentence, or on that line, is yards. Strike yards and replace it with feet.
The vice chair moves an amendment on SB 407 LC 298103-ECS on line 1251. Strike the word yards and insert the word feet. On line 1251, strike the word yards, insert the word feet. Is there any objection to the amendment? Hearing none, the amendment is adopted. Are there any further amendments?
None.
Mr. Strickland.
None, Your Honor.
Seeing none. All in favor?
Next slide, yeah.
All in favor of the motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion's adopted. Thank you, Senator Strickland. Thank you, Mr. Miller. And Mr. Abstration is carrying this on the House floor, correct?
That's correct.
Right. Thank you very much. We're adjourned.